We are talking about journalism and we're talking about surveillance of journalists. Now, in South Africa, we are relatively a free press, and there aren't that many issues when it comes to journalists and in terms of what they report on, and compared to many other parts around the world where the press may not be as free as what we think it is. And often we hear about terms like embedded journalists, and we talk about uh, media outlets towing a certain line. But when it comes to investigative journalists, because this is obviously a very, very fine line, because it is something that can obviously have serious consequences once the investigation is done on whatever the issue, whatever the matter may be, or whichever individual also you're talking about. And over the years, we've found that amaBhungane Center for Investigative Journalism, and they've uncovered a lot over a period of time. But looking at South Africa and looking at where we are, and we're talking about RICA, which is the Regulation of Interception and Communication Act. And basically, it's all about surveillance, and it is about safeguards to protect the right to privacy. And the Constitutional Court yesterday ruled in favor of amaBhungane Center for Investigative Journalism, declaring parts of the RICA Act as unconstitutional. And we're joined on the line this morning by Cherese Thakur, who is the advocacy coordinator at amaBhungane. Cherese, good morning to you. Welcome to the show.
Thank you for having me, Inayat.
Yes, wonderful having you with us. And obviously, this is a major victory for journalism in South Africa, Cherese.
Yes, it really is momentous for journalists because these protections that are now going to exist combined together will really enhance the confidentiality of journalists and their sources and really give people confidence to come forward and speak to journalists when they want to make, to talk about things like corruption. So it really is, it's something that benefits journalists, but it benefits the whole country as well, because any person could be subject to surveillance. And so these are now enhanced protections against abuse.
Cherese, let's take a step backwards. How did this matter get to the Constitutional Court in the first place?
Well, our managing partner, Sam Saul, actually discovered that a conversation that he had with Billy Downer, an advocate who was involved with the prosecution of Jacob Zuma, was included in a court application or court papers. And Sam had no involvement with this matter whatsoever. So it obviously came as a huge surprise to him to see his private conversation showing up in court papers. And if that hadn't happened, we probably would never have known that Sam's communications were being intercepted and he was being basically spied on.
Yes. Now, obviously, yes, I think what you're saying is very, very important, because I think at the end of the day, when it comes to journalists, when it comes to surveillance, as far as journalists are concerned, and, investigating, as I said, it could be an issue, it could be an individual that a person may be investigating. And in terms of protection of who your sources are, this is absolutely, absolutely paramount. But also, like you mentioned, in the build-up to building up whatever you are investigating or whatever conclusions you may reach at the end of the day, the matter, when it goes to court, there are obviously certain rules, there are certain requirements, and it's not a given that anything can be brought out in the open without the person knowing. And this is what has happened in the case of amaBhungane.
Indeed. So now, what the difference between what happened to Sam and what's going to be the case going forward is that if your communications are being intercepted and you're being watched, what will happen is once the surveillance ends, they will have to notify you within a certain period of time, which at the moment is 90 days, but Parliament may change that when they eventually amend the law. So you will have to be told. And once you know, you can go to court and challenge it and say, this was an unlawful use of RICA. They were spying on me for no good reason. I was not doing anything unlawful. I wasn't involved with the crime. So why are you spying on me? And this will be a deterrent at the very outset, because these security agents who used to go and request the designated judge in the Constitutional Court judgment, they mentioned about lies. They lied to the designated judge to say that we need to spy on this person, this and that reason. And the judge, not knowing any better, granted that application. But now, if that happens to you, you will be notified. And that is a huge development in relation to the state surveillance.
Yes, and obviously it's also about protection, Cherese, because we're talking about legal, professional privilege and confidentiality of sources as well. So it's not only about intercepting communications. At the end of the day, this is confidential information that needs to be protected at all costs.
Indeed. So it's not to say that the communications between a lawyer and their client and a journalist and their confidential sources can never be spied on. So what this Constitutional Court has now provided for in an interim reading in order that's going to be in place until Parliament amends the REPA Act is that there needs to be an extra layer of protection. So when the person is asking, the state security agent is asking, we want to spy on this person, they have to disclose, and this person is a journalist, and this person is a lawyer. And the judge has to take that into consideration. So it's an extra layer of protection. And there also has to be special direction. So the judge can say, well, we don't want to necessarily spy on all of these communications. Is there a way to restrict what you are accessing? It's extra safeguards. So it really is important for journalists, combined with the declaration of unlawfulness of bulk surveillance, which really affects everyone, but is especially important for journalists, which is monitoring people's communications that go out of the country. But it's basically any electronic communication, emails, or they can look up your specific location. When we won on this point in the High Court, Edward Snowden tweeted, "Wow." And now that is being confirmed by the Constitutional Court that bulk surveillance is unlawful, which is great for everyone. It means that your private communications are private.
Yes, and also looking at the role that amaBhungane plays in South Africa, and particularly looking at it from a journalism perspective, Cherese, where one looks at amaBhungane and until now, an organization that has been focusing primarily on exposing a number of issues, political corruption, which is basically the cancer and the scourge in South Africa, and also some of the other parts, the neighboring countries as well. So when one looks at amaBhungane and looking at this particular function, and we know that what we've uncovered, or amaBhungane has covered at this point in time, has been major, it's been huge, it's been massive, but also the tip of the iceberg, and there's still a lot more that may possibly come out, and that is why this judgment by the Constitutional Court is just so important at this point in time.
Of course, it's the protection, well, media freedom is recognized in Section 16 of the Constitution, which just really underscores that a free, independent, and fearless media is so important to democracy as a whole. It's really a vital part. And so this judgment really confirms that and gives people, as I said, more confidence to come forward and speak to journalists, knowing that they're not being, that their phones are not being tapped, for instance, or there's extra protections that can be applied to guard against abuse. And we've seen after all of these revelations of the last week, that our state security resources have been used, to further personal agendas rather than issues of state security. So this judgment is really timely and will be of benefit to everyone going forward.
Yes, I think it is a very important point in terms of safeguarding, people, personal motivations as well, because this is exactly what we're seeing coming through. And, there are many high-profile individuals who feel that, the type of work that amaBhungane is doing is going to be seen as a major threat to their personal ambitions and their personal motivations.
It's only a threat if you're doing something untoward. So if you are following the rules and by the book, we will not come for you. But that's what we're there to do. amaBhungane means dung beetle. Our job is to dig dung. So we will continue with our work, and from the advocacy side, we're going to be monitoring how Parliament responds to this order from the Constitutional Court that they have to amend this legislation, so that when the amendment to RICA comes out, it's good and doesn't bring in some of these concerns that it accords with the Constitutional Court judgment. So even though this is a great victory for us, the work doesn't end here.
Well, Cherese, I must say, if anybody wants to invest in the country, invest in dung beetles, and I'm sure there's a lot to be made out of that, just tongue in cheek. But thank you so much for your time with us this morning. We wish you well. All the best to you.
Thank you, Inayat. Cheers.
Cherese Thakur joining us this morning, amaBhungane, and this is obviously a major victory for journalism in South Africa.
Discover the Africa of your dreams and surround yourself with her spectacular beauty. Relax beneath her serene sunsets and explore wildlife at its natural best. It's where the pride of Africa